Good morning, Your Honor.
Ma'am, hold on. Okay. Good morning. Today is the day set for a pretrial conference. Ma'am, how are you proceeding? You are proceeding without a lawyer, I understand.
Your Honor, I requested this because I was hoping that she's not gonna come in.
Listen to me. Listen to me.
Yes.
I understand that you are going to proceed without counsel. Is that correct?
No, Your Honor. If she show up, I will need a public.
Ma'am, do you understand my question?
Yes, I do.
Okay. It is a yes or no question.
No.
My question is, are you proceeding today on your own behalf without a lawyer? That's a yes or no question.
Yeah. I mean, yes, can I explain?
No, you cannot. Are you proceeding today with a lawyer or without a lawyer?
Today without a lawyer, but I was hoping that you can get.
So how are you proceeding?
I would like to dismiss the case because she does not appear.
Dismiss the matter without prejudice, as the witness does not wish to prosecute the case. Is there anything else for the record?
No, thank you so much, Your Honor. Thank you so much. I'm very fan of you. I watch you all your YouTube.
Okay, ma'am, that's irrelevant. No, I said, is there anything else for the record? Is there anything else for the record? Okay.
No, thank you so much. I just have one question.
You have a great day and you stay safe, okay?
Just one question, Your Honor.
Oh, yes, ma'am.
Is it gonna go out of my record like soon?
I don't know what you mean by that. The case is dismissed.
So it's not on my record.
The case is dismissed. If you represent yourself, you have to figure out what that means.
Oh, okay. Well, I appreciate you. Thank you so much, Your Honor.
You're so welcome. Have a great day and stay safe.
Thank you.
Interested in no fans.
Welcome back to Time Served, the channel that scans the docket so you don't have to. In a special presentation, we have a Daily Docket number 2 today for you because there's just so many clips. I had to get them all in today because it was a day and a half. And look who we have on the docket today. Judge, can you get off the phone, please? Your boy Time is here.
And hi, Time Served.
Someone to sit down, like always. We have 2 cases out of Judge Boyd's courtroom today. This dude here, and then another one who likes to stick his finger in, well, I'll let you find out on that one. Then we also have Judge Cooney again, and someone has some anger management issues. He stuck something in someone's mouth and pulled the trigger, and he's claiming it is an accident. Then a couple weeks ago, I covered this lady in Judge DeSantos. She was put on probation. Well, she's back in court. She was known because she had no teeth, and she also liked to smoke crack for free. Well, she's back at it again, and here's an update because guess what? She didn't show up to probation. What a shocker. And then in Judge Lacoste, I have a 2-parter with a man in a wolf shirt. Any old man in a wolf shirt is entertainment to me. So let's just see what's going on. Then we head on down to Florida, and Judge Mercer's dealing with a defendant who has no recollection of what she did the day before. Plus, she has a limp and has no idea where that came from either. Don't forget to hit that like and subscribe, set your notifications to all, and never miss the Daily Docket. Court is now in session. Let's roll, nerds!
Hi. Miss Allen, good morning, ma'am. Miss Allen, you're here. Good morning. You're here because you've been accused of 2 things. You've been accused of. Good morning. You've been accused of 1 count of resisting an officer without violence. You've also been accused of violating the terms of your state probation, ma'am. I'm going to appoint the public defender's office to represent you in the resisting without violence case this morning for first appearance purposes. We're going to hold you on the violation of state probation to see if they get a warrant or not. But Mr. McDaniel, is this just a bond analysis or is an agreement reached?
It'll be just a bond analysis, Your Honor, and just ask to set her on a jail pretrial docket.
Can I speak, please?
Yes, ma'am.
Sir, I have no recollection whatsoever of what happened, how it happened. I don't even know what was going on. I wake up in the hospital trying to regain consciousness. I have no idea what happened.
Okay.
None whatsoever.
Corporal or
Somebody-
sergeant, the court file shows that Miss Allen was sentenced to inpatient drug treatment. There's nothing in the
Yes.
court file to show when she went or where she went. So I'm assuming it just hasn't been put in writing yet. Corporal, can you tell me when she went to the program and where she went to?
It was Sisters of Sobriety in May.
Yes.
And so
That's
we have
about
no
right.
idea when she left the program.
No, sir, we do not.
Okay.
It was
So,
I
Miss
was
Allen, I'm
on
going
a
to set your.
furlough.
Okay. Well, there's nothing in the court file authorizing a furlough, ma'am. So I have no idea. When you leave a program, that program has to notify the probation office that you've left the program, and the probation office has to notify the judge.
Yes.
So I have no idea other than this. Let me finish. I'm going to hold you with no bond because it appears you've got a condition that you go to inpatient drug treatment, and we don't know why you're not there. So even though I'm setting you a bond of $5,000 on the new charge, you've got no bond for 10 days and a possible violation of state probation. Ms. Bremer, if you notify the probation office and see if they can figure out why, they obviously have to notify Sisters of Sobriety and let Judge Garcia be in the loop and know what happened. So I'll see you in 10 days, Miss Allen, and we'll see if they have been able to decide if you violated your probation or not. But there's certainly,
they allow you
certainly
to go
looks
places.
like you might have. Questions?
But I did not resist any arrest or anything.
How do you know if you don't remember anything? Just don't talk.
Because I just,
How do you know, fam? You don't
because
know?
I don't know.
She is on probation also. So, Corporal, let's get a urinalysis after first appearance, and we'll see what's in her system, if anything.
Yes.
You have an obligation to submit a urinalysis, Miss Allen. Miss Allen, you have to submit a urinalysis because you're on probation. So if you refuse to submit a urinalysis, that's the same as having
I
a
don't
positive.
refuse.
They're going
I
to
don't
give you a chance to give
refuse.
you an analysis in just a minute then, okay?
Yes. Yes, sir.
All right. Have a good day,
Judge.
ma'am. Thank
Have
you.
a good day.
You too.
Thank you. Yes, sir. Thank you.
You're welcome.
Mr.
McDaniel.
Mr. McDaniel. Thank you, sir.
You're welcome.
All right, the city attorney has filed. Well, have you filed it?
Yes, I had, Your Honor, but it went on yesterday morning for Brooklyn. I can show you give you a copy, Your Honor.
If you would, please.
I have seen a copy, Your Honor.
You have seen a copy?
Yeah, we emailed it to him.
All right, then the city attorney is proposing here a motion to amend. In regard to the matter, then, they're changing the charge from operating while intoxicated to a charge of operating while visibly impaired as a first offense. I'm going to go over what the maximum possible penalties are for operating while visibly impaired as a first offense. You face a fine of up to $300 plus court costs are added on. You could be ordered to serve up to 93 days in jail. You could be ordered to perform up to 360 hours of community service work. If you have a prior conviction of this nature, vehicle immobilization would be mandatory. You will be required to undergo screening for substance abuse at your expense. Rehabilitation may be part of any sentence at your expense. You will be ordered to pay the costs of prosecution and costs of the police officer. Your driving privileges will be suspended for 3 months. If you're otherwise eligible to drive, and this is what's affecting your privileges, then you would have a restricted privilege to drive during that 3-month period. You have to pay the Secretary of State a $125 reinstatement fee. You'll receive 4 points on your driving record. If you have a commercial driver's license, it'll be suspended for 1 year. You could have difficulty entering into a foreign country as a result of this conviction. Canada is one of them. If you're not a citizen of the United States, a conviction may result in removal or deportation from the United States, exclusion from admission to the United States, or the denial of naturalization. Do you understand the nature of this amended charge and the maximum penalties then, Mr. Bengtson?
Yes, I do.
Excuse me, to that charge as amended, what is your plea then?
Not guilty, right?
You're accepting responsibility, right, Bill?
Oh, I accept the wrong, yes.
So
So
I thought you wanted a plea.
yeah, so your plea can be not guilty, guilty, no contest. What's your plea?
I plead not guilty.
Guilty.
Hmm.
When you're taking a plea, you plead guilty.
Well, that wasn't what I was told by the other lawyer.
Well, that was what you were told by me.
Okay. Guilty.
All right, so you understand though, if you plead guilty, there's not going to be a trial of any kind.
That's what I was trying to avoid because I'm not good under pressure.
All right, so you're aware by pleading guilty, there's not going to be a trial of any kind, neither a bench trial nor a jury trial. You're aware of that.
That would serve me pretty well because
Okay, you just got to answer yes or no, Mr. Bengtson. Do you understand you're giving up that right by pleading guilty?
yes, I do.
All right, Mr. Bengtson, do you understand you have the right to exercise each of the trial rights that are listed in this advice of rights form that you signed?
Yes,
And you understand by pleading guilty, you give up the right to exercise each of the trial rights that are listed in this form?
yes,
Do you understand, Mr. Bengtson, the court is free to impose any sentence that the court feels is appropriate up to the maximum provided by law? However, in your case, with the city's recommendation for a non-jail outcome, if I'm not willing to go along with that, I'll give you an opportunity to withdraw your guilty plea and pursue a trial. Do you understand that?
yes,
Mr. Bengtson, understanding that and the other things I've gone over here with you, does it remain your intention to plead guilty?
yes,
Are you presently on probation or parole to any court?
no,
Outside of the terms of the agreement placed on the record, has anybody promised you anything in order to get you to plead guilty?
no,
Has anybody forced you or coerced you in any way to get you to plead guilty?
no,
Has anybody told you the courts would simply be more lenient with you if you pled guilty?
not at all.
Are you pleading guilty freely, voluntarily, and understandingly?
Yes, it is a better step for me than what I was advised at first.
All right then, Mr. Bengtson, concerning the matter, I'm going to go over with you the elements as well as the date of this offense. It says it happened on or about July 16th of 2023 in the city of Kingsford, County of Dickinson, state of Michigan. Do you agree with that?
Yes,
And had you been consuming some kind of intoxicant before driving?
yes,
Said you had a preliminary breath test of 0.165 and a blood test was taken. Do you know what the results of that blood test was?
yes, I do.
What?
0.16, whatever.
We don't have the
No,
blood
we
back
don't
yet,
have a
Your Honor.
blood test back
Okay.
yet, Your Honor.
All right then. Said you were stopped for erratic driving. Mr. Bengtson, are you satisfied then, as a result of consuming alcohol before you operated a motor vehicle on the date in question, that your ability to operate that motor vehicle was in fact visibly impaired?
Yes,
All right then. I'm not sure what kind of erratic driving the complaint doesn't indicate, but erratic driving, I think, is indicative of visible impairment along with his admissions and the results of the PBT. I do think that is a sufficient factual basis. Are you satisfied, Mr. Percola?
I am, Your Honor, yes.
How about you, Mr. Brulette?
Yes, I am, Your Honor.
Is either counsel aware of any promises, threats, or inducements in order to get Mr. Bengtson to plead guilty that have not been placed on the record at this time? Mr. Percola?
I am not, Your Honor.
How about you, Mr. Brulette?
No, Your Honor.
And does counsel believe the courts complied with the taking of pleas under MCR 6.610? Mr. Percola?
Yes, I do, Your Honor.
Mr.
Yes, Your
Brulette?
Honor.
Thank you. Mr. Bengtson, I'm going to find you've made out the elements of the amended offense of impaired driving. I'm also going to find that your plea this afternoon has been made freely, voluntarily, and understandingly. I'm going to accept your guilty plea and find you guilty of that amended charge. Excuse me, you're going to go down to probation now. They're going to do a pre-sentence interview. and they're going to be making a recommendation about what they think an appropriate penalty or sentence is. That'll come out in writing. Mr. Brulette or Mr. Percola will receive that, go over it with you. They'll also let you know how much your fines and costs are. They are due at the time of sentencing. Lastly, if you haven't, make an appointment immediately to get your substance abuse evaluation done. The results of that need to be incorporated into the recommendation. Do you have any questions?
I already took an SUE test down in Escanaba. Count for anything?
Talk to your lawyer about that then.
Okay, that's all right. It's all right.
All right, thank you. We'll set sentencing on 9/21/23 at 9 a.m. In the meantime, your bond terms remain in place. You'll get that date in writing. Can I have that motion to amend then, or do you need it back?
You can have it. We mailed one, but you can keep that one, Your Honor.
All right. Anything else in the meantime then, Mr. Percola?
Thank you.
Thank you. How about you, Mr. Brulette?
Oh, yeah, thank you.
Thank you. All right, good luck, Mr. Bankson. We'll see you soon.
Tomorrow morning.
No, not tomorrow.
Yes.
Yeah,
Oh, on the other?
Yes.
Okay, thank you.
yeah, 2 within 24 hours.
Nice.
I feel like eating somewhat.
Uh-oh.
You want to wait right here? I'll walk it down in a second.
Okay.
People of the state of Michigan versus William Bankson, 237362 SM. Mr. Bankson appears here in person this morning along with his attorney, Robert Percola. The prosecution does not appear here this morning of their own choosing. We're set for a sentencing on an assault and battery charge. Have you had a chance to go over the pre-sentence recommendation with Mr. Bankson, Mr. Percola?
Yes, I have, Your Honor.
Is there anything there of a factual nature that appears inaccurate?
Just in his background, the monthly income, in discussing it with him, is somewhere more towards 4,200 to 4,400. If that matters, Your Honor.
All right. I'll make that notation. Otherwise, is there anything of a factual nature?
The reason that he's standing before you
This is the
today
last order.
is unacceptable in any context. Hopefully the letters that I provided from Mr. Benson's counselor gives some context to what was going on in his life at the time that this occurred and continues to go on. He suffered some very traumatic losses in the recent past. He is working through those things. It is a work in progress, as she indicated. I know in my time of dealing with Mr. Benson that he has been diligently working towards achieving a better frame of mind and closure on these issues, but he's still working on it, Your Honor. Yesterday's plea hearing, I'm sure it gives more indication of it's not a straight road. He's having difficulties every now and again, but he is doing those things that are necessary to get him to the place he wants to be and the place he needs to be to make sure that something like this doesn't happen again. He's got all of the fines and costs and restitution available to pay today, so that aspect of it can be taken care of. I did discuss the content of the letters with the probation department in terms of the recommendation for the particular kind of counseling. I think, and Ms. Miller thinks, that just continuing the counseling that he's already engaged in perhaps be the best course going forward. So we would ask that the court consider allowing him to do that as far as the counseling intervention here. Other than that, Your Honor, I think all of the other recommendations are form fit to the situation that Mr. Benson finds himself in here. I'm sure that if he could go back to this time and place, he would make different decisions, take the high road and not be drawn into the situation that he was, but he has to deal with that and move forward. And that's what his plan is to do here, Your Honor, and he's taken positive steps to do that. So, thank you.
Thank you.
Just that it took a lot to be provoked because I don't do that. I don't do that. It's the first time in my whole life that I've run into this situation. But
And what have you learned if that ever happens again? How do you handle it?
it can't happen again because I'm not going to bars anymore.
Well, that's a good help. But I mean, if you get provoked, are you learning and counseling alternative methods to handle your anger beyond physical response?
Yes, I'm seeing the counselor and I got to see her again.
So what are you discussing about that, for example? Has she given you any tools or any alternatives when you get angry?
We're working on that right about now. She hasn't really come out and said, she hasn't really come out and said we're working. I went there because I think that I had some anger issues.
Uh-huh.
And we're trying to work through that right now.
How many times have you seen her?
About 8.
Well, Mr. Perkla, I don't know. I don't feel very confident about what type of, I don't think they're talking about anger management type of issues. It doesn't sound like to me.
Well, the most recent letter, it sounded like her plan going forward was to include emotion dysregulation and anger management skills. I recommend Mr. Bengtson continue to meet with me and to work through his grief and on emotion dysregulation. So,
all right,
that hasn't been part of the plan, or it sounds like it is going to be rolled in as she deems fit going forward here. I don't know if it was her idea to deal with some of the core issues first before moving on to those areas. That's what it sounds like to me, but
when did Lita pass?
Year and a half ago.
I'm sorry for your loss.
Thank you.
All right, Mr. Bengtson. I am reading the letters here, Mr. Perkla. I think that she's recommending he have a psychological evaluation in the future for, various issues here. I'm going to just modify the terms here slightly on the probation to be consistent with what the experts are recommending here for him. All right. I'm going to place you on probation for 6 months, Mr. Bengtson. I think that you deserve an opportunity to demonstrate that you as well made an error in judgment and that this is not behavior that you're likely to repeat. All right. There'll be a 6-month term of probation, $200 oversight fee for probation. Fines and costs on the assault and battery are $440. Presently, there is restitution of $137.45 payable to Mr. Stephen Plonka. I'm going to order that. If there are any future claims for restitution, I'm going to leave any future restitution set at 0, and either side may petition for a hearing. Crime fund fee is $75. The justice system assessment fee is $50. $1,202.45. I'm going to, she's a PhD clinical therapist. So remaining in places of business where alcohol is sold for use inside, such as a bar. You may not use, possess, or consume any non-prescribed controlled substances or prescription medicines that aren't prescribed to you. You must avoid all people that use, sell, or possess those items. Recreational marijuana use and possession are prohibited. You're subject to random PBTs and drug screens while you're on probation. You may not engage in any harassing, intimidating, threatening, or assaultive behavior while you're on probation. You may not have any contact with Mr. Stephen Plonka while you're on probation. I can't hear you. You understand the terms of your probation then, Mr. Bengtson?
Yes.
All right, you're going to receive those in writing this morning, along with the advisal concerning early discharge from probation. All right, good luck to you, Mr. Bengtson.
Thank you very much.
All right, Thank you.
Okay, so coming up now is the Judge DeSanto clip that from today, where our girl here, Mrs. Gabrielle Thomas, up in the right corner, claimed that she could not urinate because she's on bladder medication. And that was the reason why she could not provide a sample. Lo and behold, that's really not the reason, of course. So I'm going to show you a couple of the highlights from the July 16th hearing for all the probation violations, and then I will show you what happened today where she did not provide samples yet again, and we find ourselves back in court. So, without further ado, let's go to the clips.
Am I unmuted?
Yes.
Okay. Gabrielle Thomas.
All right, thank you. Ms. Thomas is currently on probation for controlled substance use, and it's alleged that there's a violation of probation. She failed to appear for drug tests on June 24th. June 15th and 16th, she appeared but could not submit a sample. And counsel?
Your Honor, my client is aware that she could have a violation of probation hearing in which she could contest these violations, as they are technical violations that will not be necessary. She's prepared to admit to the violations.
Individual. But during that conversation, did you indicated that you had medications, correct?
Yes.
Okay. Did you indicate what your medication was for, the purpose of your medication?
You know what? She just asked me what they were. No, I did not. I don't believe.
So you didn't? Okay. So when it was explained to you regarding how the testing works, did you at any point discuss with either the individual that you received your instructions by or your probation officer the fact that you're on medication for bladder issues?
No, Your Honor. I was so overwhelmed by the whole. I'm sorry.
Ma'am, that is your responsibility to do that.
Okay.
So that there can be a resolution for that. But then, absent that, you didn't even appear for your testing on June 24th.
I had no money or no way to get there. I explained it to them. I'm on a fixed income. When I did go to test, I had to borrow money that had to be paid back. I was borrowing money to go. I do not have that type of money to pay every time for testing.
Okay, ma'am. I'm sensing an attitude, and you do not.
I'm not having an attitude. I'm about to cry because I'm upset. I'm sorry, Your Honor, if you think I have an attitude, but I don't. I'm just upset. I'm sorry.
We're going to do a jail review on August 21st. At 10 a.m. Okay. Ma'am?
Yes, ma'am.
Any additional violations, you'll serve this 5 days plus any other jail time.
Okay.
July 29th, August 2nd, and then the next probation meeting is July 20th and July 27th.
Correct. Correct. All right. And ma'am, please raise your right hand. You solemnly swear from the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
Okay. And ma'am, you heard the plea that your attorney indicated, correct?
Yes.
As to the allegations that you failed to attend your probation appointment on July 20th and July 27th, how do you plead?
Yes.
I can't hear you, ma'am.
Yes.
As to the allegation you failed to appear for your drug testing on August 2nd and July 29th, how do you plead?
Yes.
And you gone over your advice of rights for probation violation purposes, correct?
Yes, ma'am.
And you understand all of those rights. You also understand that by entering into a plea that you'll be waiving some of those rights, specifically your right to a contested hearing.
Yes.
You understand the possible penalty as a result of your plea, correct?
Yes, I do, Your Honor.
You understand that the recommendation in this matter is for probation to be revoked, close the case without improvement, $50 probation violation fee, 25 days jail, which would be 20 days in this matter, an additional 5 from your jail review. You understand that's the recommendation?
Yes, I do.
And you understand this court could adopt that recommendation in full, in part, or deviate from it completely.
I do.
And knowing all that, you still want to continue with your plea.
Yes, I do.
All right, counsel, if you can please report to your client.
Yes, as term condition of your probation, you were ordered to test. Did you miss the testing on July 29th and August 2nd? Yes, I did. As a condition of probation, you were ordered to meet with probation. Did you fail to meet with them on July 20th and July 27th? Yes, I did. Satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, factually accurate. The court will accept your plea. And the probation violations indicate technical violations 4, 5, 6, and 7. And counsel, as to the recommendation, at this point, we can also do the jail review recommendation. Your client had pled guilty to a probation violation on July 17th, at which time this court sentenced your client to 5 days jail, suspended with the jail review August 21st. She was also supposed to submit documentation regarding her issues as it relates to her bladder by July 29th to probation. And the court will note that she did not submit that letter. And since there were additional violations, this matter was moved up to today's date. And so, counsel?
Yes, Your Honor. My client indicated that she did in fact go to get that letter, and that letter was in fact, according to my client, faxed to the court. So at this point, I've not seen the letter, but she indicates that was attempted to complete. As to the current violation, Your Honor, my client is of limited means. I don't believe that it's out of malicious behavior that she is not testing. It's rather due to the fact that she doesn't have the financial means for transportation, as well as the additional financial needs to comply with all the testing. However, she did appear to court timely. She had to take the bus to get here. Judge, she indicates she is doing the best she can, and unfortunately, the best she can is not in full compliance with court. I would respectfully request leniency in considering the appropriate admonishment for my client. Thank you, Your Honor.
Did you submit that documentation to the court, ma'am?
I went up to first.
You went up where?
To the doctor's office. I called that day. They said they were sending it. They faxed it. They said the letter was sent. They faxed it. I went to the doctor's office that day and had them look it up when Georgia was sent. And he said, yes, the letter was sent. So I'll have to go on what they,
So did you contact Ms. Shaw to confirm that she received it?
No.
What's that?
No, I did not.
Well, man, you really should have done that. But besides that, you didn't appear for probation appointment on July 20th and July 27th. That has nothing to do with any payment issues. Why didn't you appear for court or for your probation appointment?
On the first one, I was doing my intake, and she had told me 24th. I didn't know she used up the day before. And at that time, I was doing my intake at positive energy. It was around 3 hours long.
So did you communicate that with Ms. Shaw?
If I'm not mistaken, I left her a message.
Okay.
I can't say I'm positive, but I'm pretty sure that I did.
All right, so what happened on July 27th?
I didn't know I had one on July 27th. So the only one I knew about was on 27th.
The 21st of July or the 21st of August?
21st of July.
Okay. Please, there's no talking in court. You can talk out in the lobby, please, okay? All right. And then why didn't you appear for drug testing on July 29th, ma'am?
I didn't have a wedding. I didn't have one.
I'm sorry?
I didn't have a wedding and I didn't have one.
Did you communicate any of that to Ms. Shaw?
When she talked about testing, she said that had to do with it. That comes from somewhere. So I don't know what I'm supposed to do.
Okay.
This is all wrong to me.
Do you work, ma'am?
No, I don't. I'm on disability.
Okay. And you know that you're testing throughout the month, correct?
Yes.
And you know that the tests are $20 each test?
Yeah.
That's yes?
Yes, ma'am.
Okay. And so do you set any money aside so that you can have that money for testing?
I tried, but honestly, by the time I get through paying what I have to pay, I have no money. I have very little money, seriously. I get less than $1,000 a month. I'm paying for my rent. I paid for my loan. I paid for it. I have a loan. I'm paying that. So I paid for it. I don't know. I'm sorry.
But at some point, ma'am, at some point you were able to have some controlled substances in your possession. And so what about August 2nd? You didn't appear for your testing that day either.
I didn't see anything like that. I don't check my phone at all. I turn it off. It irritates me. I'm bipolar. I'm up, I'm down. That irritates me. When I do check it, I'm seeing not scheduled, not scheduled, not scheduled. I may not have checked it that day. I don't know. I don't check it every day. And I'm being honest.
I understand that, ma'am. You've been on probation since June 13th.
Right.
This matter was reduced from a felony to a misdemeanor.
Yes, I understand.
You were sentenced to 24 months of probation, and it's been less than 2 months, and you've now had 7 violations. What's in your system if you test today?
I did something last night. Because I said I was I smoked half a joint.
I'm sorry, you smoked half a joint?
And did a $10 rock.
$10 rock.
Did I do my shit?
Did you pay for that? Did you pay for that rock? No. Somebody gave it to you again. And then what about the joint that you smoked? Did you pay for that?
Yeah.
I'm sorry?
They haven't.
I can't hear you.
They haven't yet, so no. I just get it a couple times.
All right, well, here's what the court's going to do. The court's going to indicate the court's going to revoke probation. The court's going to indicate 20 days jail on that matter, $50 probation violation fee. The court's going to also indicate on the jail review that that's 5 days, so a total of 25 days jail.
Texas versus Andrew David Guerrero. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Alfonso Cabañas for the defendant, Andrew Guerrero.
And are you Andrew David Guerrero?
Yes, ma'am.
I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Andrew David Guerrero who's placed on community supervision in 2021 CR 6159 for the offense of evading arrest, detention with a vehicle on November 19, 2021 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4. In Bexar County, Texas, the defendant Andrew David Guerrero did then and there fail to report to the supervision officer as directed for the months of February and March 2022 in violation condition number 4.
How do you plead to that? True or not true?
True, ma'am. And Your Honor, we'll waive the remaining violated conditions.
Any objections to the waivers?
No objections, Judge.
All right. Did you understand by pleading true to violation of condition number 4, court will find it true. The court could find it true, grant the motion, sentence you up to 3 years in the prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, there is, Your Honor. And the consent did not deny the motion, extend the individual for 6 months and amend conditions to add state ISS cognitive behavioral track, and also have the probationer be supervised by the gang unit. That is also the recommendation by probation.
All right, counsel.
That is the recommendation, Judge, in conferring with my client. He's asking the court to follow a recommendation by the probation office.
All right, General, raise your right hand for me.
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Andrew David Guerrero.
All right, so why are you not reporting?
I have no excuse, but it was just around COVID and I was having hard times and that's it.
2022? That's COVID time? We were having court in 2022, were we not?
Yes.
And this plea was taken. Yeah, I don't understand.
I was just having a hard time and I'm just.
All right, so why are you people are always throwing COVID around?
Well, no, because I mean, I was looking for a job. I couldn't find a job. I was just having a hard time.
But what does that have to do about picking up the phone and calling probation?
Well, I had COVID at that time and I was reporting, but my probation officer had stopped me from going in and I was just calling and calling. And that's it. And I just stopped.
Here's the thing.
Just not.
You can't be before me and being dishonest, because I tell you what I will do. I'll have probation zoom in and let me know what's going on. I know COVID doesn't travel through the phone lines and they're saying you did not report. That's a problem. So basically what you're telling me is that you had COVID for the months of February and March.
No.
So why are you being dishonest with me?
I'm not. I'm just
making up reasons for not doing what you're supposed to do. Here's the thing. And this is what I've discovered in my time on the planet. When you do something wrong, you know what the best route is? Usually, I'm not going to get into legal discussions, but usually the best route is, I was wrong, I'm sorry. And guess what? When you say I was wrong, I'm sorry, the other person on the other end, if they don't accept your apology, then that's on them. But you've done all you can do. You can't go back in the past and mess with the time continuum and report. So why were you not reporting?
just having a hard time, man. I'm sorry. Okay. I was just having a hard time.
All right.
I didn't have a place to stay. Didn't have a job. You know, I was just having a hard time.
And what's with the drug issue? Do you have drug issues?
No, not at all.
Mm-hmm. All right. Anything else from either side?
Not from defense, Your Honor.
I'll deny the motion. I'm going to extend you for 6 months. State ISF, cognitive, and gang supervision. All previous conditions remain, and that means the no contact with Brianna Castillo. Is there anything else?
No, yeah, that's fine, but I don't see how she's coming up if that was like that was just a previous condition.
Because that's part of your conditions. No contact with Brianna Castillo.
Oh, okay. Well, yes, ma'am.
All right. Is there anything else you need from the court to be successful?
No.
All right. And then probation upon release. I'm going to want GPS and he's allowed to work. So it'll be partial for work. Are we ready on Wallbacher? Oh, no, I'm being told he stuck his finger in water and in the testing, which I find very suspicious. Yeah, no. Nobody does that.
And I was trying to take
No. Court is calling 2023 CR 0889 State of Texas versus Stephen Wayne Wallbacher. Could I have parties announced for the record for the state? Defense.
Ron Ross for defense.
Are you Stephen Wallbacher? You entered a plea on June 15th, guilty to count 2. According to the plea bargain agreement, punishments to be assessed at 8 years in the prison. The state is silent on your application. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, we have, Judge. And by the way, it's a capital H.
Ah.
Yes, and state asylum, Judge.
All right, if y'all want to, oh yeah, it is a captivate. Okay. And the state is silent. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
We have, judges, just one correction or
Yes.
in the TAP evaluation down about toward the end of it, said that he's continued to use marijuana since he was arrested. And he says that's not true. He said since he's arrested, he was using it before, but since that he hasn't used it. That's what he tells me.
Well, we can't get a UA because he stuck his hand in the cup. Nobody does that. I don't know anybody who would purposely or accidentally stick their hand in a cup of urine.
I just did, when there was no urine, ma'am, I just grabbed the cup. I didn't even.
Yeah, nobody does that. You wasted a UA in this court.
I can.
So, counsel, anything you wish to say on behalf of your client?
Judge, I would say that he's 55. And I think his report, he's got child support obligations. He looks, I don't know that he's not diagnosed as mental slowness, but it seems to be. And his jobs, he's not had real good jobs right now. He works at a cook, but he is employed. He's been employed, and I don't know that at this point in time, sentencing in the prison is going to really make much difference or correct his behaviors. I would ask you to make him do outpatient treatment. Let's see if give him a chance. I mean, I agree with you. I think it's kind of ridiculous what he says, but give him out.
Oh, I would tell you, counsel, outpatient treatment is going to be out of the question. He's going into custody today. So either he's going to prison or either he's going to treatment. Those are his choices. Either he's going to safety. I know they're recommending SADC, but for someone to purposely invalidate a test, that tells me a little bit where he is with regards to his sobriety. So either you have a choice. You can go to safety or you can go to prison. If you wish to go to prison, I will sentence you to 4 years. Which do you choose, prison or treatment?
I'll take treatment.
All right. The court will sentence you to 8 years in the prison. Thank you. Suspended and probated for 8 years. Take in consideration 2023 CR 0888. Thank you. Got to sentence you to Safe P, followed by aftercare. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be the UA hotline upon release. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. Field visits 1 time per month for 4 months. And if everything is going well with the field visits, probation, I'm going to want random field visits after that, and you'll be able to pick how often you wish to do that. There's to be 200 hours of community service restitution. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Judge, anything else?
Anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. You do have a right to appeal since there were issues raised through pretrial motions. But however, this is a felony conviction. You're not allowed to own or possess any weapons or ammunition, any body armor or anything of that nature. Do you understand? If you have a question over what a weapon or ammunition is or body armor, you'll need to speak to an attorney. Do you understand? We can go off the record. Mr. Wahlberger, here's the thing. When I ask for people to do UAs, sometimes I know that people are going to come in and they're going to be positive. I can see the signs when people are going to be positive. The reason why I'm asking is because I'm trying to determine, one, your level of truthfulness, and two, where you are in your sobriety. And when you are dishonest with me about your sobriety, you know what that tells me? That tells me you need to be in somebody's inpatient treatment. So you're going to inpatient treatment because of you. All you had to do was take the UA instead of sabotaging the UA test. You understand?
Yes, ma'am.
All right. Good luck to you.
Case number 23-444-6201. The defendant is charged with 1 count of assault aggravated. Today is the date set for final pretrial conferences as to each matter. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Your Honor, Austin Gregory, P85193 on behalf of Mr. Kennedy, who's present by Zoom. Mr. Kennedy, please unmute and state your full name for the record. You have to unmute first, Mr. Kennedy.
You have to be still too. This is too much. This is too much, Mr. Kennedy. It's a table over there. Can you go sit down at that table? This is too much. Oh, blessed assurance. Oh, did I say that? Oh, I said that. Oh, okay.
Right there with that microphone. You should be able to hear it.
Hello? Can you hear me?
Yes, Mr. Kennedy, please state your name for the record.
Thank you. My name is Marvin Kennedy.
I've been wondering, can you hear me? Because if you can
Yes,
hear
ma'am.
me, well, you're certainly not following my instructions.
Ma'am, respectfully, Your Honor, I could not hear you.
It's no respectfully. No. Respectfully, Mr. Kennedy. Look like you need to come to court in person. Now, I got a feeling we might have gone through the same thing the last time you came. Well, let me say this. 36th District Court is open. We're open for business.
Okay.
What I'm not going to do is wait for you to walk from your house to your porch, from the porch to the yard, I'm not going to do that, Nick. I am not going to do that. Now you need to be ready for court. I'm certain that I said earlier, remain stationary.
Yes, ma'am, you did.
Right. I know I did. Please don't interrupt me. I said remain stationary. Seated in an upright position, ready to attend court. You did not remain stationary. You were not seated in an upright position and you were not ready to attend court. I'm not going to do this with you again. Next time I'm going to delete you from the screen and a warrant is going to go out for your arrest. You need to come to court in person. Mr. Gregory, how are we proceeding today with these 3 cases? All of them are scheduled for final pretrial conference.
Your Honor, we are asking that these not guilty plea be continued and that they be set on track for a jury trial.
Well, okay, and I'm gonna give him a jury trial too, because this right here is too much. It's too much. And he has 3 cases and we're going to trial. And we're going to trial this year. Because this right here is too much to take into the new year.
And further, Your Honor.
All right, then, Mr. Kennedy, you're all set. And on August the 30th, the hearing is in person. So put that at 9/12. That's in person. It's too much. It's too much.
That's
And right, anything further?
Nothing further, Your Honor.
The report sets forth everything from either's perspective perfectly.
The fact that probation doesn't believe it is, well, somewhat important. You may recall this plea was a no contest plea. The agreement from the prosecutor was no upfront jail time. And your commentary during that was that if you do order jail time, you'll permit a withdrawal. Ms. Morton's ordered, or recommended rather, I'm sorry, Ms. Morton recommends you order, recommended no probation, some jail, fines and costs. Probation could be problematic. I've represented Mr. Alexander in the past. He is a good guy. His record, though, does show violence, and he has not had great success on probation in the past. I would, in my perfect world, fines and costs would do it, but I've let him know in no uncertain terms that you're probably not going to go with that. You're going to want either jail or probation. You're going to want to try to modify his behavior or punish him for this by having him sit. So I'm respectfully requesting, in light of that, despite my best day, I don't think I can get that reasonably. A short term of probation, maybe some programming, maybe this time it will go for how to deal with conflict and how to deal with anger so that we don't have these types of instances coming up in the future.
All right. So I would like to hear from you, Mr. Alexander. Anything you'd like to add?
I'm extremely sorry that all this happened. And since he has not been coming around, we have had a lot better luck with everything and getting along more. And everybody is more cohesive without the victim coming around anymore. And I'm sorry that it all came down to this.
Okay. Ms. Olson, anything for the people?
I would just say that my hope when I agreed with Mr. Kane to not recommend jail time was that there would be some sort of probation and some services. It sounds like there is some interpersonal conflict here that could be helped with some sort of services, whether that's anger management or potentially counseling. And so that was my hope when I made the offer at that point. Thank you.
All right, thank you.
I don't disagree with that assessment, Your Honor.
All right, so this is sentencing on the defendant's conviction of assault and battery. It was a no contest plea. And the court did agree to no upfront jail time with at the behest of the prosecutor. The facts are that there was a argument between the defendant and the victim who was at the home of his ex-wife, or I guess it was her mother's house.
It was Mr. Alexander's home.
It was Mr. Alexander's home.
But the victim here was at his home, at Mr. Alexander's home for a child exchange.
Okay. Well, anyway, to drop off the child, and there was arguing, and at some point the victim, Mr. Kummer, said that he was in the car with his girlfriend, that the defendant came at him and he had a ratchet in one hand, he had a fire extinguisher in the other, and sprayed the fire extinguisher directly into Mr. Kummer's mouth. The defendant disputes that. He says that the fire extinguisher went off by accident. He did admit he was holding the fire extinguisher for protection, but why he's coming at the car if the defendant's leaving, that doesn't really make sense. He should have stayed put and let things simmer down on their own. The recommendation was for jail time, and that was because the defendant does not admit to the assault. It's kind of hard to rehabilitate someone when they're not admitting that they did something wrong. And I can understand that. There's also the statement that he has had anger management counseling in the past. That would have been when he was a juvenile. But Mr. Alexander is 36 years old. And so that would have been at least 20 years ago. So anyhow, I do feel that anger management would be helpful. It seems that that was the primary point of this agreement with the prosecutor to place the defendant on a probationary term. I am concerned the defendant is not taking responsibility for his actions, but you know, when someone's in a car and they're ready to drive off and you approach them and you know, there was just no reason to further involvement. So anyhow, there's also the added concern that there be no contact between the two. Mr. Alexander says things have been a lot more peaceful. Keep in mind that the no contact is going to apply to you, not to Mr. Comer. But obviously, if he's coming around, then he's purposely violating the no contact. So that's not something you can do anything about. But anyhow, I'm going to place the defendant on probation for a period of 1 year. There will be a fine of $100 cost, or $800. There's a $75 Crime Victims' Rights Fund fee, $50 judicial system fee, and a $275 court-appointed attorney fee. The conditions of that probation are that the defendant not engage in any violent, threatening, intimidating, or harassing behavior toward anyone. Defendants not to be in possession of any weapons or firearms or reside where those are present. Defendant is to complete the men's program through Second Chance, attend all sessions without any unexcused absences, and fully cooperate in that program. The defendant does have a history that involves OWI, and so I think I'm going to also require that he not, I realize it wasn't involved in this particular incident, but the defendant is not to consume or possess any alcohol, no mind or mood altering substances, no non-prescribed medications, and no illegal drugs, obviously. There will be discretionary testing only for those substances. And let's see, there's also no contact with Josiah Comer. You're not to go within 500 yards of his residence or workplace. The child exchanges are to take place through a third party. And I realize this is not your daughter, correct? This is so. I don't want Mr. Comer forced to come to your home because that would be a bad situation. I'm not sure that the mother's home makes any sense either, given what happened here.
The mother shares a home with Mr. Alexander, Your Honor.
Oh, is
The
that,
mother is
that's the
Mr. Alexander's girlfriend. They
situation?
reside together.
Okay, so it needs to, the child exchanges should take place somewhere other than your home. He shouldn't come to your home for those exchanges. So it'll have to be done preferably in a public place, but I'm just going to say through a third party, not through you or your mother. Okay, I don't believe you were not arrested.
I was not.
Okay, all right, so there's no credit for time served. In addition, I'm going to order that the defendant serve 3 days of community service work. That's 24 hours. And, you know, anytime you spray somebody in the face with a fire extinguisher, that's pretty bad. I think you need to think about that while you're performing your community service work. Is there anything else for you, Mr. Kane?
There was 1 day credit. He wasn't arrested at the time. He was arrested at the time they served the warrant. So he has a day.
So he was booked in. Okay, so there's credit for 1 day served.
Thank you.
All right, if there's nothing else, then we're all set for this morning.
Nothing further. Thank you.
Okay, thank you.
Yo, this is too much. This is too much, Mr. Kennedy. It's a table over there. Can you go sit down at that table?